This is related to a statement made by Montagraph's attorney, David Schneider, which is a fucking lie because David Schneider, at least in my case, is an unethical, lying piece of shit. And I'm sure he's going to send this to the ethics board. Fuck you, Dave. Fuck you right in your stupid head. And that probably, I guess, is also a rape threat. I don't know. But if you lie to the fucking court, you're going to get called out. You got called out. Stop being a beta bitch about it and just own up to the fact that you hyperbolized and lied about what was said. If I say I'm going to bend you over and fuck your ass in court, I'm not literally going to go into the courtroom, pull your pants down, bend you over the fucking railing, and have anal sex with you against your will, you fucking weirdo. I don't know what fantasies you have about that, but I'm obviously saying I'm going to destroy your case. I'm going to win in the courtroom, and I'm going to laugh while doing it, and you're not going to like it. That is the implication. But to go in before the judge and try to prejudice a judge by saying that it's a bona fide rape threat is dishonest, and you fucking know it, you goddamn liar. And send this one to the ethics board too, I guess. And our friend at the ethics board who's been reviewing all of this shit and is probably primed to dismiss your fucking bullshit complaint can review me saying this. I'll say it 100,000 times. The First Amendment is the First Amendment. I never gave it up because I have a law license, and fuck anyone, including the ethics board, if they want to take it away when I have not violated a single fucking rule, and you have lied every single fucking time, including saying that I was a pro se litigant when your dumb motherfucking ass wouldn't just answer a goddamn phone or an email for me to tell you I'm represented now. I'm represented now. All you had to do, you had to admit this to court, you bitch. You had to admit to the court that you were too fucking ass hurt over something from years ago, apparently, that you wouldn't answer a phone call or an email. So instead, you just lied over and over and over again. And why do you think the court granted the extension I had just asked you to grant as a courtesy? Because it was the most basic, obvious request that anyone asks for, and you tried to be a cunt about it. And then you bitched when you got called out, crying to the fucking ethics board. Ugh. But guess what? Guess what? When you send this one to the ethics board, hi, Mr. B, you know me very well by now. I'm sure you're tired of getting complaints about it. But let me just go on record and say that David Schneider, again, is being a fucking cunt. And as a non-attorney, as a represented party who is broadcasting through his First Amendment rights, David Schneider, with even a cursory reading of the First Amendment, knows that I can say that he's being a fucking cunt, and all he can do is not like it. Because as stated, I was not represented when I said it the first, or I was not representing myself when I said it the first time. And for the record, even if I was representing myself, broadcasting to my YouTube channel that David Schneider is acting like a fucking cunt has nothing to do with any legal activity, filings before the court, or any ethics violations at all. And I will fight to the fucking death and to the Supreme Court if necessary to protect my ability to give an opinion on someone being a fucking cunt. But that fucking cunt has lied about me to you, Mr. B, several times, as he has to admit in the bitch up letter that he sent to the court that we're going to cover next, and probably in the bitch letter he sent to you. But this guy, if he would just stop acting like a fucking cunt and act like a professional, maybe I can go back to calling him a professional like I did when this started. The only reason I've ever called David Schneider, and actually, let me just say, I've never specifically, until today, I think, said he was a fucking cunt. I said he was acting like a cunt. But the only reason I ever said it is because he was. And I will stand by that position forever. I will never, ever apologize, capitulate, or back down from that stance, because attorneys are held to a standard. They are held to a standard of candor before the court, of rules, of congeniality to opposing counsel. And when I was opposing counsel to David Schneider, he broke all three of those rules. And he continues to break candor to the court, and he continues to break candor to the ethics board, as we'll cover in his response letter, in which he lies to the court again, in an obvious way, and probably lies to the ethics board. I'm sure I'll find out when I get an email about it. But I will never back down from my First Amendment goddamn fucking right to say things in the most profane way possible, because you cannot censor a fucking opinion. And that is a bedrock principle of the First Amendment. And fuck anybody right in their goddamn gay ass if they want to oppose that. And if I have to go deep into the case law, I'll put on the latex glove all the way to my fucking shoulder and do it. I am so goddamn tired. These are attorneys. David Schneider is supposed to represent people who have been raped, who have been violated, or more appropriately, who have done the raping, who have done the violation, who have spoken the unthinkable. That's what attorneys are supposed to do. They're supposed to represent us against the government. They're supposed to be our advocates when some oppressive, tyrannical force steps in with more power than us and says, we're going to stop you from doing that thing. And some attorney is supposed to stand up and say, no, because we have a system of laws and rules that says, fuck off, tyrant. You can't do that. And Dave Schneider is trying to bend those rules, trying to bend government towards censorship. Why? Because his fucking pathetic feelings got hurt. Fuck your feelings. If I have to stand up for every attorney's First Amendment right, then I guess that's what I have to fucking do. This concept that some government, first of all, decided we needed a license to be an attorney, which I would argue is unconstitutional, by the way, just so we're clear. But a government decided we have a license to be an attorney and then gets to regulate our First Amendment because of their decision to impose a licensing requirement? No, man. Not cool with it. Never fucking will be. If you're going to make a licensing requirement, you damn sure better not infringe on rights. Let's get to this letter. My bad. I got some feelings I need to get off my chest. Dear Judge Fisher, as the court is aware, I have the privilege. Come on. Oh, Mark. Great story, Mark. The privilege. This poor bastard. I have the privilege of representing defendants Nicholas Rekieta and Rekieta Law, LLC in the above referenced matter. I'm writing to the court to correct a serious misrepresentation made at the April 10th, 2023 hearing by David Schneider, attorney for plaintiff Steve Quest. Schneider falsely represented to the court that Mr. Rekieta threatened to rape him and his client. Exhibit A, transcription of April 10, 2023 hearing at 13 minutes, 7 to 14 seconds. The April 10th, 2023 hearing was argument on defendant's anti-SLAPP motion, seeking judgment on plaintiff's defamation and emotional distress claims. The only issue before the court was the sufficiency of the evidence plaintiff had and the legal sufficiency of the claims, all of which arose from Mr. Rekieta's statements made prior to the filing of the amended complaint. Although defendant's counsel sought an opportunity to respond and rebuttal, the court declined to entertain rebuttal, which is fine, I suppose. I think the court should have allowed rebuttal, but they, what do? The court doesn't allow it. They don't allow it. Thus, defendants had no opportunity to counter or correct the immaterial, impertinent, and scandalous remarks. Ooh, scandal. Defendants wrote to Schneider on April 14th, requesting he substantiate his allegation. A copy is attached as Exhibit B, and notably, defendants also indicated that they expected Schneider to correct the record if he could not substantiate his allegation, quote, before the court relies upon or is prejudiced by such misrepresentations. So Randazza wrote a letter to Schneider saying, hey, you said something that wasn't true. There, by the way, it's an ethical rule for a lawyer who misrepresents to the court to correct it, and a lawyer who knows about a material misrepresentation to have the court correct the material misrepresentation. The reason is the fact finder should be concerned with facts that are provable, discernible, showable. But when you lie about what happened and one party knows about it, they have a required duty to tell the court about the lie. Now, as a courtesy, what you do, it's kind of a courtesy. It's kind of a, hey, you fucked up. You better own up or we'll own up for you. You contact the other attorney. You say, hey, by the way, we noticed this thing is not true. If you want to go ahead and tell your version of the events to the court, so long as you correct the record, that would be fine. Maybe you say, I only saw the part of the clip where he said this. I didn't see the in-court part or whatever. So he made a hasty decision. We overgeneralized in our zealous representation of the client. Whatever it is, you just go ahead and you have the opportunity to explain it away. But if you choose not to do it, you're on notice now. The other party noticed, and they will tell the judge, hey, this guy lied about what happened. If they don't want to correct it, kind of looks more like a lie than an accident. So they sent the letter. Hey, you want to go ahead and fix this? You know, you can go ahead and do that. It wasn't correct. You can go ahead and tell the judge, hey, overstated this, whatever. It wasn't actually a rape threat, but it was heated dialogue. You know, they get to frame it. David Schneider chose not to do that. So now we've got this letter. On April 17th, Schneider transmitted a video of a portion of Mr. Rekieta's April 1st, 2023 broadcast in which he claimed the claimed rape threat occurred. Copy is attached as Exhibit C. There was no such threat. Obviously, there's not a threat. First of all, threats have to be pretty fucking specific. And there can be no ambiguity at all. And by the way, there is no ambiguity in what I said. It was obviously meant to mean in court, considering I fucking said in court. It's clearly relating to the case and what will happen in the case. On April 19th, we again wrote to Schneider laying out our concerns and requesting that he correct the record. Copy is attached as Exhibit D. Rather than taking corrective action, Schneider lackadaisically responded, quote, relax, counselor. And then I've got to say this in pussy-ass bitch voice. I already provided the court with a copy of your client's vulgar and rude video. I also sent it to the lawyers board. It speaks for itself. Can you imagine being like this? Can you imagine being this much of a fucking pussy? I sent a copy to the lawyers board. Nobody sees a dean. Like, what are you? What even are you? Oh. A copy is filed herewith as Exhibit E. The video was over 10 minutes long and no transcript was submitted. Thus, while the video may, quote, speak for itself, Mr. Schneider should speak for himself when doing so, do so truthfully. There is nothing that any reasonable person would characterize as a threat of rape. This was thoroughly explained in our April 19th, 2023 letter. See Exhibit D. Schneider's response was not in disagreement. Instead of abiding his ethical duties, he is letting his misrepresentation potentially prejudice the court as it considers the pending anti-SLAPP motion. The court has the inherent authority to take any and all necessary action. Minnesota Supreme Court in Hughes versus Hughes utilized this inherent authority against a litigant before it. Noting, quote, so this is a 1939 case, noting, quote, the aspersions upon the trial court contained in appellant's brief and made in his oral arguments are wholly unwarranted and are scandalous in their nature. See also in re Clerk of Courts complaint for Lyon County versus Lyon County Commissioners. announcing that inherent judicial power comprehends all authority necessary to preserve and improve the fundamental judicial function of deciding cases. Now, this is critical because Schneider's going to be like, he's going to say something completely untrue about this being properly before the ethics board rather than being before this court. But the problem for Schneider is that he lied to the court. He lied to the ethics board. That'll be a separate issue for him to fucking deal with. But lying to the court is separate from lying to the ethics board. So the court has authority and the ethics board has a separate authority. But his lie to about the ethics board is even worse. We're going to get into that. And is available to courts on all levels to be used consistent with respective jurisdictions and functions. It's comparing to Patton versus Newmar Corporation, discussing how courts are vested with considerable inherent judicial authority. The inherent authority of the courts was recently reaffirmed in Anderson versus Anderson. This is an unpublished opinion on Lexis. It's only published on LexisNexis, not in one of the registries in 2018. In Anderson, the Minnesota Supreme Court awarded attorney's fees where atypical, vexatious conduct warranted the imposition of a sanction. That Schneider's misconduct is vexatious may be informed by the Minnesota Rules of Professional Conduct, Rule 3.3A1, which states that a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to a tribunal by the lawyer. Schneider knew it was false and failed to take real corrective action upon being put on notice. Rule 4.4a requires that, quote, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. Schneider actually tried to use Rule 4.4a against me, which is also a lie. Schneider's misrepresentation had no substantial purpose other than to embarrass and burden Mr. Rekieta. This is true because the burden is my lawyer has to work to correct the record that Schneider fucking lied about. That's a burden. And he's trying to embarrass me before the court by saying I made a rape threat, which, by the way, let's just be fucking clear, an actual threat of rape would be illegal. It would be a criminal act to threaten to actually rape someone. So not only is Schneider lying to the court, he's falsely accusing me of a criminal act before the court, where, if believed, the court could theoretically, although they won't, recommend criminal charges to the district attorney. And oh, wouldn't that be fun to deal with? You felony threatened to rape Schneider. Rape Schneider? He's not even my type, bruh. Too fat. Schneider knew it was false and failed to take real corrective action upon being put on notice. Rule 4.4a requires that in representing a client, a lawyer shall not use means that have no substantial person. Oh, wait, I read that one. Rule 8.4d states that if it is professional misconduct for a lawyer to ... engage in conduct that is prejudicial to the administration of justice. And make no mistake, Schneider's entire purpose is to be prejudicial here. He's trying to prejudice the court. This is a bad man who threatens bad things and does bad things relating to speech. Therefore, you should not grant his motion for summary judgment based on speech. In falsely asserting that Mr. Rekieta made rape threats, which had nothing to do with the merits of the anti-slap motion, Schneider sought to improperly inflame the passions of the court against Mr. Rekieta, banging on the table where neither the law nor the facts were on his side. While we are not presently moving that the court strike the remarks or sanction Schneider, we are obligated to highlight the serious nature of this misrepresentation to attempt to mitigate the prejudicial effect. This is not Schneider's first misrepresentation of the court. The court will recall the misrepresentations made in the complaint and amended complaint about Quest's state of residence. In response, Schneider responded not by admitting error or providing actual evidence to corroborate Schneider's claims that Quest was an Illinois resident, but rather attempted to downplay what is either his knowing misrepresentation or lack of due diligence and feigning surprise that the resident of a plaintiff could possibly be an issue in a case involving multi-state parties, which is just stupid, by the way. See supplemental affidavit of David W. Schneider, filed February 22nd, 2023. No further misrepresentations should be countenanced. We thank Your Honor for her continued attention to this matter. Should the court require any supplemental information and or briefing, we would be happy to provide such. Signed by Randazza. There we go. So that is Randazza's letter to the court. I don't know if you guys have noticed. I care autistically about the First Amendment and the right to free speech, such that, let me just say it, because of my autistic attention to how important free speech is, I have adopted a style of speech that is diametrically opposed to polite society. Because I have established myself in a position to do so intentionally for the benefit of everyone else who is constrained in their freedom by a third party. I say f it so you don't have to. I say cunt so you don't have to. Because the idea that you can't say a word because someone else's transitioned vagina gets wadded up with their leftover tighty whities is offensive to me. The idea that someone gets mad over the syllables and arrangement of letters rather than the intent behind them is pathetic and a sign of weak people in weak times. And I prefer the strong men of tribulation that wrote down that our freedom of speech was so fucking sacred as to put it in a place of primacy over all other rights. To recognize first that our thoughts and expressions manifested through syllabic slappery was so goddamn critical that we should never be condemned, judged, or jailed because of them. And any fucking loser who wants to say that someone can't say something because it offends their sensibilities should be strung up and shot in the fucking street. Because that's what the founders would have done. And actually did. And I'm sure that will be construed as a murder threat. But I'll say what everybody knows right here, and right down fucking here. Just so that you guys don't have to. Until you free yourselves from the shackle of third-party interference.